We're very excited for our fireside chat on uncovering the use of generative AI in judicial contexts. We welcome to the stage first our moderator, Cédric Wachholz, Chief of Section, Digital Innovation and Transformation Section, UNESCO, with our panelists, Professor Juan David Gutierrez Rodriguez, School of Government of Universidad de los Andes, with Linda Bonyo, founder, Lawyers Hub Kenya, and our two virtual speakers, Miriam Stankovich, Principal Digital Policy Specialist, DAI, and Kimberly H. Kim, Assistant Chief Administrative Law Judge, California Public Utilities Commission. Off to you, Cédric, and thank you all.
Thank you so much. Good. Thank you so much. A warm welcome, and I'm happy that so many people made it after lunch and in time. It's really incredible how the Future Society manages to keep us all on time. This is an exciting session. We will speak about how can generative AI really be a legal administrative enabler without becoming a threat to fair trials and subject to litigations. In just 35 minutes, we will have a very short introduction by me, and then Professor Juan David Gutierrez will briefly present preliminary findings of the survey I announced before, done in 97 countries with over 500 participants on generative AI uses in the judiciary. And then we'll follow a few comments by panelists. We will get a sneak preview on the recommendations following of this survey. And after a short round, again with panelists, we will close. So I'm very excited. Let's dive just right in. We know how generative AI systems can be useful, and judicial actors can shortcut and automate certain tasks and gain valuable insights from a vast amount of of data. And there are, of course, also risks attached. We discussed hallucinations yesterday as a so-called, and you know, most of you know the case in June where in the US a judge imposed sanctions on 2 New York lawyers who had just submitted 6 fictitious cases generated by ChatGPT. And there are other examples. I have a few more, but I will not go into that because time is really tight and we have really exciting things. But we have all these individual cases and examples. But what we really want to do is also take a helicopter view, look at the global survey, and look at what is happening really across the world. And for that, I hand over to Juan.
Well, thank you very much, Cédric. It's great to be here. And there's cases not just about lawyers who copy-paste some output from a chatbot with non-existing rulings. There's also cases by judges who happen to do the same very recently in Brazil, for example. I mean, everyone can be caught, right? And as Cédric was explaining before, UNESCO is conducting a survey that up to now has received answers from almost 100 countries, both by practitioners and judges. There's a good balance between them in the survey. And what UNESCO wanted was to understand how judges and practitioners are actually using or not generative AI, and what are their perceptions about risks, about potential uses. This survey will help us draft future guidelines for the use of AI in judicial contexts. And I want to tell you a few highlights of these preliminary results of the survey. So first thing is that we asked judges and lawyers whether they were familiar with AI. And the answer from knowing nothing to being an expert, you may see like a normal distribution in the answers, but more or less half of the people say they're moderately aware of AI. So people in general are acquainted with it, but there's a gap between knowing that it exists and actually using it. So when we ask whether they used AI tools, and also we ask whether they used large language models like the ones that can be accessed through ChatGPT, the answer was quite different because around 70% of the respondents said that they have never used it, or that if they had used it, it was not for professional purposes, or that maybe they had used it a few times. So there's like a huge gap on opportunities of use, right? But then when one asks them what types of uses they can explain, or like there are around 3 or 4 consistent answers related to search of information regarding rulings, legislations, doctrines, or specific topics. That could be a matter of concern, given that the outputs of chatbots are normally not reliable and should be contrasted. But they also use it to synthesize text, to summarize their own decisions, for example, and to explore new topics. So that's the type of uses that the respondents more consistently made. And the survey also addresses the issue of negative impacts, where the people think that there's maybe negative impacts regarding their professional use in judicial contexts. And almost 70% of the respondents said that yes, that they could see that there could be negative impacts. And when asked what type of problems that they saw, particularly regarding generative AI, the more salient or most salient answers were security concerns, so data security, false information that could be included in the answers, or the fact that the information is not reliable, potential copyright violations, as well as privacy and data protection concerns. So they're actually big concerns, because it's not just about getting accurate information, it's also about fundamental rights. So one can see why judges and some lawyers may not be eager to adopt this type of technologies. And to give a segue to the next discussion, we also asked them whether their organizations had some sort of rules about the use of generative AI. We asked them whether they had received training, formal training, and whether it would be useful that an international organization like UNESCO issued guidelines to help them. And the overall answer is 86% have not received any training. So there's a huge gap. There's a huge opportunity here in digital literacy, right? Over 70% said that there were no mandatory rules in the organization or any type of rules, but they also answered predominantly that they thought there should be mandatory rules for the use of AI in judicial contexts, and 92% of them said that it would be worthwhile that UNESCO published guidelines for the use of AI, particularly generative AI by judicial operators. So I'll stay like this. Thank you.
Thank you so much, Juan, for summarizing so such a short 560 survey results from 97 countries. Now we will go through comments from Miriam Stankovich first, the Principal Digital Policy Specialist at the Center for Digital Acceleration. And the question is really, from your perspective and experience, which challenges and opportunities have you identified and which mirror perhaps partly of what Juan just showed us in your country context? Miriam, over to you.
Thank you, Cédric. I will begin with the opportunities. So it is undeniable that Gen AI has the potential to transform the legal profession and the judiciary. Now, the technology, if used transparently and with ethical and legal guardrails, can be useful in legal research as well as providing suggestions for depositions and oral arguments. However, it is also important to understand, as you rightly noted, that generative AI models are trained using large amounts of data, and as such, these models are not flawless. So Gen AI tools can produce plausible, but not necessarily factually correct outputs, and this is because the design of these tools is geared towards producing outputs that are similar to, but not exactly the same as the source information they use. And I see three primary concerns with using generative AI in the judiciary. So number one, you mentioned the tendency for some types of generative AI to create fictitious information, that is hallucinations, potential for bias, and the black box problem. And legal stakeholders should exercise caution while using it, and appropriate measures must be taken to mitigate this risk. For instance, legal documents often contain complex and unclear language that requires precise interpretation. And tools such as ChatGPT may struggle with the nuanced and context-dependent nature of legal language. In large language models, as noted by Professor Juan, they have increasingly demonstrated a potential to hallucinate, right? So I'm not going into, different types of hallucinations that might be spit out by these models. But for example, in the last few months here in the United States, we have had different instances of judges either relying on ChatGPT to give inputs on existing jurisprudence regarding legal questions, or and not just judges in the US, but also elsewhere in the world, but also lawyers who submit depositions in litigation. What is more, if the training data used to train these models contains racial or gender biases, the model may perpetuate or amplify those biases, and this could lead to unfair or discriminatory outcomes in legal context. And these models are mainly neural networks, and they're considered black boxes. So in terms of decision-making processes, even the developers of the model do not understand how the model makes its decisions. And as Juan rightly noted, training and education and being aware of the risks and challenges that come with these models, not just regulation and governance, but also working on digital skills, especially on the digital skills of judges, so they understand what they're dealing with. It's really important. And there are different cases. You rightly noted one in the United States. That's the US case of Mada versus Avienka, where the lawyer used ChatGPT to draft a legal document, but then to also verify the authenticity of supporting case law. And, the model just spit out a case law, which was, which looked like authentic, but it was not. Okay. So, and then the court found that the lawyer had acted in bad faith and sanctioned them under Rule 11 of the Federal Rules of Civil Procedure for submitting fabricated evidence, falsely attesting to having made a reasonable inquiry as to the law, and misrepresenting to the court the basis for seeking an extension. And then several other judges in the United States have followed suit and issued orders regarding the use of Gen AI in court filings, and each with their own unique approach. And because we are running out of time, I would just know the approach which was taken by a senior district judge in the Eastern District of Pennsylvania, which has taken an unorthodox approach, mandating disclosure of any use of AI and requiring litigants to certify the accuracy of citations in their filings. And also the order directs counsel to reveal the use of seemingly harmless programs like Grammarly. So we need to differentiate. Not all generative AI models are created equal, and there have been some judges in the United States who also have mandated have prohibited the use of Gen AI. So I'm going to stop here and back over to you, Cédric. Thank you.
Yes, thank you. Thank you so much for these examples, Miriam, and for sticking to time too. You spoke about the hallucination, the bias, the black box, and some also automated decision making. And it was wonderful to hear these concrete cases. I hand now over to Linda Bonyo, founder of the Africa Law, Tech, and the Lawyers Hub Kenya. And can you provide us some examples which would also show generative AI users opportunities and risks too?
I think that technology is good for a lot of the world, but I also think that technology is very contextual, and especially in this case, generative AI, and how we receive technology is different across the world. I was doing a training a few years ago, like 3 years ago, and I was teaching lawyers and judges on AI. And I went on and on for 45 minutes. At the end of it, one of the judges raised his hand and said, you know, when you kept talking about AI, I kept thinking that we're talking about artificial insemination. And I just got to understand what you mean at the end of it. And I said, by the way, it's the same concept, that you ideally are not too intelligent, and then we make sure that there's an external something that's helping you develop your intelligence. But having said that, this was a judge of the High Court, and this was 3 years ago. At least, thankfully, a lot of the things have changed in the world. But I'm surprised by how we leave behind the judges in our quest to fix technology and to find out what to do with technology. I'm also surprised by how we throw gadgets at judges and not necessarily skills. And sometimes this is a political problem, because it's easy to steal. Where I come from, corruption is rife. It's easy to steal when you say we gave out 2,000 iPads than really say we trained 2,000 judges to understand what this particular means. But I also think that there's a very AI, and especially in the context of generative AI, is really pointing to the foundational problems that we have around technology. One, around the use of public resources. For instance, around the world, what do we do with what communication authorities are collecting in terms of universal service funds, and how to use that for digital skills. But I also think that we have a data gap. Where I come from, I'm based in Kenya, and ideally, if you do any checks on ChatGPT, it's not as accurate as what you have in the US. And so when we go into large language models, it's basically who has the data really runs these particular platforms. And so we have a data gap that has not been filled. And then two, we also have a vendor lock-in problem. Kenya has a great platform which documents all our legislations and together with our case law. But this was developed by Google around 15 years ago. And so really it's tied to Google. And Google is not the only problem. We have Microsoft that's running a lot of our platforms on judicial platforms across Africa. And that's not a problem if you're in a country that has strong institutions like the US, where there are checks and balances. If you come from a country where the GDP of your country is less than what Amazon makes in a year, then really you have no particular ways in which you can make these particular platforms accountable. I'd also just want to highlight how within the startup ecosystem, there's a lot of work that's going on towards innovating around ChatGPT and generative AI by extension. We have Lopadi in Nigeria that's really doing amazing stuff in this particular front. And we also have Timi that is like this legal research platform that's ideally helping lawyers by use of AI to do this. Africa still grapples with the virtual court problem. And when you talk to many of the people in the context, they will tell you, if you ask them, what do you do with technology? One of the things they will boast about is to say, yeah, we have virtual courts. But that's not anything, because they haven't developed these platforms. These are third-party platforms that ideally they're using to get into justice. Kenya just came into a deal with the East Africa Data Center to boost its data center capability. If you know what that means, especially in a continent that our subsea cables, Facebook is providing internet across the African continent. Our subsea cables are privately owned and not necessarily public digital infrastructure. And that tells you that we still have a capacity gap in that sense. And then finally, I would want to maybe talk about what do we do in the sense of what do we learn from what has happened before with AI. I think it's useful to acknowledge that we come from different contexts. My context is very foundational. Can we be able to fix the skills gap? Can we be able to fix the infrastructure gap that makes sure that we ideally have no computing power? Electricity in Kenya is expensive. South Africa is going through load shedding, so they only have electricity at certain parts of the day. Nigeria people are using generators. Like ideally, women are dating men because they have generators. and then now you have access to ideally work. That's really different from what you experience in these particular countries in the West. I think to close the global southern sort of divide is to look at ways in which, let's talk about the nice technology, but let's talk about the must-haves. What is this must-have that we can ideally have? Computing power that ensures that we're just not consumers of technology, like we've seen with ChatGPT, that Africa is simply doing data labeling, and we saw this with Samasos, as highlighted by Times magazine, that Africa is doing the data labeling, collecting of the data, but they ideally not controlling the capital that goes into venture capital and anything that goes in terms of owning the particular technology. Thank you.
Incredible. You speak very fast, but the number of topics from artificial insemination down to the data gaps accountability, I would have loved to hear more about the innovation part, but also the must-haves, the infrastructure and skill gap. You really brought us up in a holistic approach and a global approach. So thank you for bringing these in. And over to Judge Kimberly Kim now, Assistant Chief Administrative Law Judge at the California Public Utilities Commission.
Well, thank you to the Future Society for inviting me to this timely global conversation with this esteemed panel. By way of introduction, I'm no expert in AI. I'm the Managing Administrative Law Judge with the California Public Utilities Commission, as you mentioned. I am based in San Francisco near Silicon Valley, where I dine at restaurants with robotic servers and drive next to autonomous vehicles daily. I also sit on the American Bar Association's Tech Committee for the Judiciary, and full disclosure, I come to this issue as a pragmatist and with cautious perspective on AI and GAI. With that, I'll share some challenges that I see in the US judiciary as we face today's AI and GAI world, and also share some thoughts on them. The most difficult challenge for the US judiciary, not unlike the other jurisdictions, as both Juan mentioned and other panelists have mentioned, is in preparing the judiciary, who I think one of the commenters mentioned are laggards, to this fast developing technology to help one understand it and its beneficial uses and risks, to harness it as productivity tool where appropriate, and 3, develop operational responses to other implications and risks of AI and GAI to the judiciary and judicial functions. You all know that judiciary is rarely seen as eager early adopters, and most fall in the resistant camp when it comes to the change or technology. We didn't need Juan's survey to know that. I think that's commonly accepted. Thus, proactive training and educating of the AI and GAI issues to prepare the judiciary is imperative, as the world of AI and GAI is here and now. Judicial management at every level, therefore, must take charge in this endeavor now to ready the judiciary for these changing times. Relatedly, the judiciary must be ready for potential operational system impact, both in quantity and quality of cases and court proceedings. Court dockets should see increase, and those increases will come from various sources. We should be monitoring varying claims under various traditional theories, such as fraud based on use of GAI, or copyright and patent infringement cases involving inputs and outputs from GAI platforms, to name a couple. Court dockets increase should be anticipated also due to additional GAI generated or aided new claims, routine filings that are automated, and discovery and other litigation activities fueled by, related to, or otherwise resulting from GAI use. And lastly, new AI-GAI related claims and lawsuits will arise from the new AI statutes and existing statutes that are being amended to include all AI-related claims. Currently, in addition to the series of federal AI legislations, more than 30 US states have one or more AI-related legislations pending or enacted, and many, many more are expected in the coming year. And finally, as we face this new world, the judiciary must take a responsible and ethical leadership role in the legal system to ensure that those most disadvantaged and vulnerable in our society, and those who lack access to these technological advantages and tools are provided due process and fair treatment in the judicial system while up against those who have access to these powerful tools. That means for the time being, AI-GAI tools may create significant strategic legal advantages in both speed and volume of legal research, drafting, discovery, and other facets of legal practice to those who can afford some of those costly legal GAI tools that are now becoming available and rolling out as we speak. I just saw, I think, Reuters Group roll out one of its GAI tools couple weeks ago. We must look at what that means from fairness and meaningful access to justice perspectives when average persons are so disadvantaged when they come before our judicial system. I implore my colleagues, therefore, to carefully weigh these concerns as they see these cases come before us. And finally, and relatedly, that ethical, responsible leadership also means, like all the cases that we just sort of heard mentioned, modeling responsible and ethical use of these tools by judiciary and those supporting the judiciary, if GAI tools are used in the judiciary, and holding the lawyers to that same high standard of ethics and competence in the proceedings and courtroom before us. Thank you.
Thank you so much, Judge Kimberly Kim. You mentioned also a number of important points preparing the judiciary to ready them up to monitor fraud using generative AI. Then you highlighted how so many AI-related judgments are pending, but also something of a generative AI gap where you have those big companies who can afford big investments in this domain, and there's something of a new divide appearing apparently too. And with some modeling of responses there. Now that leads over, we have really covered quite a lot of different domains, and the question is now to Juan, Professor Gutierrez. What would be the recommendations and guidelines have to include to respond to all that?
Well, this is my preliminary thoughts, and I'm very happy that I'm here to listen to other people. I think that we need guidelines both for organizations and individuals. So for organizations, we need rules regarding the AI tools that are being procured. What I mean by that is that it's given that the justice sector is probably a high-risk environment for using this type of tools. The tools that are being deployed by the justice sector should be sufficiently tested, and the human rights impact probably should be also assessed before the deployment. We need also, regarding the organizations, internal proceedings for security. This means that we need measures related to the technology, the human talent, and the managerial aspects of security. Regarding the human talent, we do need that the judiciary prepare judges and offer and probably also promote that lawyers educate themselves in this matter. And regarding individuals, there's a question of whether individuals should use this tool without having enough information. We need informed use, because as it would occur, let's say with a car, we wouldn't like someone to drive a car if they don't know how to use it. Well, the same will happen with a judge in the justice sector whenever an AI tool is being used. And we also need some guidance on what are the ethical and responsible ways of using it. We need specific guidance on how judges need to, for example, avoid including private or confidential information in the prompts that are used in AI chatbots. And also we need specific guidance on how the judges disclose or not disclose how they use AI chatbots, as well as lawyers. As Miriam just gave an example in Pennsylvania, there's other places in the world where there's a question on transparency and how much to what extent there should be transparency, even for the clients that are involved in the cases. And this guideline should be broad enough to allow specific jurisdictions to draft their own context-specific rules, but we need guidelines that are specific enough to have actually influence in whatever application of AI systems is deployed in the justice sector. Thank you.
Thank you so much for this sneak preview on the guidelines work and the recommendations, both for organizations and individuals. I will not repeat them, but hand over because we have a hard cut at 35, where Joshua Bonyo will be coming in 3 minutes. We are out. 1 minute to wrap things up. Wait, I will start with Miriam. I was looking to you, but I will do the round as we did before. Miriam, in 1 minute, please.
Yes, so I have suggestions and recommendations based on recommendations that Juan made at macro level, and I'm going to repeat some of what other discussants have said. So data quality and digital infrastructure and contextualization at macro level, if we talk about international development and different contexts, different countries, that's number one. And then for public policy stakeholders, addressing these challenges will require a combination of technical improvements, legal and ethical consideration, and ongoing collaboration between AI developers, legal experts, and policymakers. And this is all. And then for judges, for the justice sector, human in the loop, always cross-verify data. There should be human in the loop. Don't forget, AI is not neutral. That's it. Thank you.
Thank you, Miriam. Over to you, Linda.
Thank you very much. I think that we should talk about interoperability because there's too many interventions that don't speak to each other within the judicial system and too many technologies about this. I also think that too, it's important to talk about tech aid and what that means because we have vendor locking coming in and flouting procurement rules just because the technology was free, so we didn't ask all the questions. I think that's a huge problem in my side of the world, and we need practice directions that speak to transparency. Transparency of what data came in, what came out, and what are the impacts. And I think learning from Eric versus Wisconsin, the case around predictive policing, really indicates that at the end of the day, Black people would be disadvantaged by certain systems when they ideally do not have access to this particular data. Thank you.
Thank you so much. Also, Judge Kimberly H, please.
Sure. I stated some of my recommendations during my segment, but I'll wrap up by saying one of the most important thing at this juncture, I think echoed by many of the panelists, is that we have to get our judiciary to be proactively trained and trained and trained. We might be a little slow on the uptake, but I think repetition helps, and we will take all the support we need. That's just one of those things that I'm very passionate about, and I've been working on daily these days. Train, train, train. The other thing is to be ready operationally. We have to monitor the case developments and what that means on our docket, and to be ready. And again, that means we are going to see the variants, as I mentioned, and variant claims, as I mentioned, as well as increase in the types and different activities that come before us. So we need to be ready operationally for that kind of increases, as well as the new legislation based claims. And lastly, and I think I really feel strongly that, again, in the very near future, we are going to see a version of the digital divide that we saw, and that is this tool is going to roll out in the legal system in a much more reliable way. We're not going to be relying on ChatGPT, we hope, but the legal system, GIA-run legal systems are going to be costly. And we are going to find a way to somehow play a role in ensuring that we provide our parties that come before us fair treatment and due process.
Thank you so much,
Thank
Judge Kimberly Kim. It was really a fast-paced, very rich, fascinating discussion and panel. I have one regret. It is that we can't build on the collective intelligence of this room. So I'm sure there's so much more to be said, but we will consult all of you and reach out to you once we have the first draft of the guidelines ready, and we count on your inputs. And I thank the panelists here in the panel and at a distance, and all the audience too. And I hand back over to the moderator.